So you know, the reason for the delay is we, there were, there was some paperwork glitch in the paperwork that the clerk needs to have for votes. So we're waiting to clear that up. So we have the proper names and of the people on this committee, and then we'll be able to get started. Thank you for your patience. All right, I'm going to call the executive session of the House Judiciary Committee to order, and I'd first recognize Representative DiLorenzo to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Thank you, Representative DiLorenzo. All right, so I think what we'll take up first is the bill on which where is it? We had a sort of ad hoc group that worked in more detail since our last executive committee meeting on Monday on HB 169, and so I recognize Representative Kutab, please.
I make a motion to ITL 169.
Is there a second?
I second it.
All right, seconded by Representative Manos, and Representative Kutab, would you like to speak to the motion?
Yes, so this was a very difficult bill for us. We did meet for a pretty good amount of time. We all read through a pretty extensive amount of cases, several of them which Chairman, you had actually concurred on in your time on the Supreme Court, and it just, as much as we feel for the family that we heard from, we have a concern that this bill has the potential to do more harm than good, because it seems like it's ripe for challenge, and it may not necessarily have even helped in this case, because we're not defining kind of what that level of evidence is, and it is somebody's judgment, and everybody's human, and sometimes the way that we decide things is different than how somebody else would decide, and we do plan to look further to see if perhaps there's something that we could enter for next year that may make more sense. But unfortunately, it just seemed as though, due to the constitutional right that the parents have, and the fact that this is a consensual guardianship, and that it wasn't ordered on the basis of the parent being unfit, that unfortunately requiring more than a preponderance of evidence doesn't seem like it would stand the test. So we did review everything, and we didn't take this decision lightly. And it's unfortunate, but it seemed it was best to ITL the bill.
Any other comments? Yes, Representative Perez.
I think the fact that you're concerned about whether it would stand up in the courts, personally do not feel that that's a reason to ITL this bill. My biggest concern with this is that the child is not being represented. And if a child, whether it's with agreement or not with agreement, there was a problem with this family. They were drug addicts, and they agreed to have the child taken by the grandparent. If a child is put in, and then they were given back to the parents, and now they're in foster care. I think this happens more than we realize it happens. And my concern about this is that the child is not being represented. And being having a drug abuse problem is an illness, and the illness doesn't go away because you're always a drug addict, you're always an alcoholic, you always have the potential. I think that parents, it's hard to take parents away. It should be hard to allow a child back into a home. I just am very uncomfortable with it. I had thought about perhaps just having it studied longer, but it has to be more than 51% that these children go back. I know of many, many, many cases. We just had two huge public things here in New Hampshire that went nationwide about children that were lost in the system. Who's speaking for the children here? I'd like to speak for the children. I would like to see, if you lose your child because of something, abuse or drug addiction or alcoholism or whatever, then you have to fight. You have to prove more than, okay, I went to rehab to get that child back. Thank you.
Yes, Representative Kutak.
I completely agree with much of what you just said. I think part of the concern was that even if the judge had, let's say, used a level of preponderance of evidence and not given back a child to the parents, that this may give them reason to challenge and say, well, the law is clear and convincing, and even though you maybe only use preponderance, they're going to say your level of evidence was too high, and that's why you didn't give the child back. And so that's where it has the potential to do more harm in that somebody who was rightfully kept from getting their child back may be able to appeal on the basis of believing that the level of evidence required had been too high. And that's where it was really got in the weeds.
Sure, Representative Perez.
And I understand that, and I understand where you're coming from, but if you have to work harder to get your child back, because it's all based on, someone making that decision. If you have to work harder to get your child back because it's not overwhelming that you're due to, then work harder rather than have that child be given back to you and then turn around and have the child suffer. These two national cases that were here, these children were given back to parents. 2 children dead.
Representative Manos.
I was part of the smaller group, and 2 of the cases we looked at are Troxel, which is a U.S. Supreme Court case, and Rena D., which is a New Hampshire Supreme Court case. And I think they're controlling precedents. And I think that's why we made the recommendation that we look to the future to reconsider these issues, and that if we went beyond the amendment that was proposed, we would be that it would be non-germane, and so that was why we made the recommendation to ITL.
All right. Anyone else want to speak on this? Yes, Representative Andrews.
Thank you, Mr. Chairman. My thing is on this, does DHHS need to tighten their rules and regulations and do a better job? And that's where the problem lies. Thank you.
Any other? Yes, Representative Greason.
Thank you, Mr. Chair. The 2 court cases, Troxel and Rena D., the dates of them are 2010, 2011, something along those lines. And it appears that current RSA has been modified since then, and I've not been able to determine what modifications those exactly were, but perhaps because of the language of the current law, it appears like the modification to have the grandparents in a where the guardianship was by consent, and what we are looking at potentially modifying again looks like the modification came after those cases, in response to the cases. And if that's true, and I think we should verify that, but if that is true, then that's after, and it has sustained 10 years of jurisprudence. And so I don't see how Troxel and Rena D would then interfere with the ability to modify it again. And so if someone, I think that I have to agree, I don't want to ITL this bill because I think that if we can at least find out if we can, when these modifications were made, we can modify it again.
So, well, yeah, yes, go ahead, please, Representative Kruta.
So we were able to find, or I was able to find the case that the legislation actually came from. It was the case of Matthew P. And you may remember this better than me, Chairman. It was recommended that legislator take a look at this to make a change from the Matthew P. case. And that's where this legislation did come from. In my looking, it seemed like the better place to make the change had to do with, in the case of foster care, there's a 12-month permanency hearing, which then the adoption goes into effect at the 24-month mark. That hearing doesn't happen in the case of a consensual guardianship, and it seemed that that was the place that the change actually needed to take place. But unfortunately is a non-germane amendment, which is why we were kind of locked on what we were limited with.
Mr.
So-
Chair?
Yes.
So, given the light that I think we're all in agreement that we would like to see if we could do something, could we retain this bill instead of ITLing it right off the bat?
So can I just, if the question is could we retain it? Yeah, I mean, we could vote down, the motion on the floor is to ITL. We could, if that motion failed, then that we certainly could entertain a motion to retain. I guess what I would say, and I will recognize Representative Manos in a moment. There's two points that I think I would make, and I hope you'll consider. The first is the problem, I think, with the proposal is this. As the Troxel case points out, and as the Rena D and other cases, and there's other cases from around the country point this out, the parents have a fundamental right to the upbringing, to raise and bring up their children. And the problem that with this proposed amendment is this proposed amendment would say, even if a court were to conclude that the parents had, cleaned up their act, so to speak, so that they were now fit parents, even if the court were satisfied that it was more probable than not that that was true, the parents would still lose because they hadn't satisfied this higher burden of clear and convincing evidence. And so what that really, I mean, if you stop and think about that, that means you're a fit parent. You come into the court and you prove now that you're a fit parent, whatever may have been your past track record. You now come in and you prove that it's more likely than not that you're a fit parent, and you lose anyway. That's, I think, where the constitutional problem would come in, to say that you can make it harder than that. So that's why I have a real problem with the proposed amendment, even though I am sympathetic to what people are saying. The other thing that I would say, and I hope you'll consider this, is the main evidence in support of this bill comes from a very compelling witness who appeared before us, but gave us her side of a court case. We never, yesterday I was working here yesterday preparing some amendments for some other things, and the Child and Family Committee, I was in that office, they were in here, so I could hear a fair amount of what was going on. There were any number of bills presented to change fundamentally, in fundamental ways, the way the family court operates. Many of those bills based upon, what somebody told somebody about a court case in which they got one side of the story. And that's what we got here. Please understand, I'm not saying for a moment that judges don't make mistakes. They do. And in fact, it appears from what I understand about this case that in fact, the the child ended up, the parents ended up going back to drug dealing and whatever, or drug abuse, and the child was taken away again. So I'm not, that could indicate that the court made the wrong decision. So I'm not saying that courts never make incorrect decisions, but what I am saying is, and I hope you'll just think about this, is I think it's dangerous to legislate based on a particular case and getting one side of the story. Because I can remember last year, and a particular legislator coming to me a number of times and talking about, this happened in this case and we need to change the law, and we need to change the law. And on several occasions, I thought to myself, I think I have a pretty good sense of who the judges are in the state. I don't know them all or by any means, but I think I have a pretty good sense generally about this. And I remember saying to myself on a number of occasions, even in the worst, think about the person that I think the least of as a judge in the state, and that was having a bad day and maybe had a little too much to drink the night before. Even in that circumstance, this judge could not have made the decision that was suggested on the facts that were related to me. It's just, incredible that could have happened, which tells me there must have been another side to the story. And of course, we don't have that. We haven't read the transcript of this case or those cases or anything. So I guess I just say, I think it's kind of important to put that in perspective. Representative Horrigan.
Just to underline what you said, and your comments were on the spot. I many years ago, we very briefly had a thing called the Petitions and Redress Committee, which was a failed experiment, and that was almost entirely people with very civil cases had gone sideways, usually defendants in family law cases, and of course they would usually, even if they brought documents, they would usually only bring copies of their own documents, like the ones for their case, which is understandable. And then it was pretty easy to pull a file if the case has gone to the Supreme Court. The clerk will in a few minutes bring you the case file, and you can sit out there and read it. And just about every case, I found that there were fairly severe. There's a fairly severe difference between what we were told happened in the case and what the case file actually reflected. So there's usually a rationale for what the other side of these cases were doing. Not to say that necessarily all the petitioners were wrong or they're all right, but there's one particularly amusing case where he was always saying the judge was doing things for no discernible or rational reason. So I finally got hold of his case file, which was particularly long. I think he had 1,000 items in the docket, and in every case there was a discernible or rational reason for what the court did. So that's that is a problem with legislating based on one party's possibly one-sided and often very incomplete summary of what happened in the court case. Thanks.
All right, Representative Kutab.
Would it be possible for us to do some sort of a subcommittee or little study with a few of us to possibly propose a bill for next year rather than retain this one? Because I just don't think this is the area that it would go in. I think it would be a whole new bill. Is there any way that we could do some little subgroup with us?
I'm sure. I mean, the answer to that doesn't have to be something that's done. The answer is yes, but that doesn't. I think that's not something that we sort of have to act upon here. Yeah, you may. I mean, I would encourage anybody on this, this committee, and if there's other committees that have an interest in it, maybe Child and Family or whatever. If you think you have, ideas for making the law better, you certainly should do that, and I would encourage it. Yes, Representative Perez.
In my notes, and correct me if I'm wrong, because again, I apologize. I'm going to use the excuse it's new, but I have in my notes that a Brian Clark testified, and I have written down DCYF wants to keep clear and convincing.
I think that might have been on the first part. Yeah.
That was in section B, and they have been neutral to the change in section C, but I should note that DCYF doesn't have involvement with the consensual guardianships typically, and so that's why they were neutral on it, because they have limited involvement. But the clear and convincing, they were just saying, please don't make the change in Part B, which is why I had made the amendment.
Mr. Chair.
Yes, Representative Di Lorenzo.
Thank you, Mr. Chair. I think that we are looking at this issue through a very narrow lens. A parent or parents could lose custody of their children due to no fault of their own, such as mental health or physical disability. So I think that when we do look at this bill, again, we need to look at it with a wider scope. Thank you.
Anyone else wish to comment? Yes, Representative Manos.
I just wanted to suggest that one reason not to retain it is because jurisdiction might lie with children and family law. And so I agree with Representative Kutab that looking at it further individually or as a smaller group informally would be the better course of action.
All right. Anyone else wish to speak to this bill? All right, so the motion on the floor is to ITL HB 169. Are we ready for the question? All right, so I'm going to ask the clerk if you would please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton is absent, Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk, yes. Rep. Perez,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. Di Lorenzo.
Yes.
The rep that's subbing for Kenny, I'm so sorry, I didn't get your. Rep. Eaton?
Correct.
Is that a yes?
Correct.
Yes.
Rep. Page? Rep. Brennan?
Yes.
Rep. Devine?
Yes.
Rep. Lanza?
Yes.
Rep. Manos?
Yes.
Rep. Turer?
Yes.
Chairman Lynn?
Yes.
19 yeas.
All right, so that the ITL passes, and it any reason that that could not go on consent? All right, it will go on consent. Then let me turn to next. Where are we? House Bill 320. FN and the relative to free speech and interactive computer services, and the chair recognizes Representative Greason for a motion.
Thank you, Mr. Chair. I move that House Bill 320 be found inexpedient to legislate.
All right, is there a second?
I second that.
All right, seconded. Representative Greason, would you like to speak to the motion?
Yes, sir. Thank you. House Bill 320 is attempting to prevent social media platforms from censoring content posted by users. And that is, we have seen over the last few years where this has occurred, and in great amounts. Federal law distinguishes between platforms and publishers. This is section 230 of the federal code. A platform is one in which the social media company allows users to post the comments and such that the users want to post on there, and within a reasonable amount of content regulation, the social media platform is able to, they allow them to post whatever those things are, and without liability for those comments. In contrast to a publisher, where the social media company would then be actually controlling what is posted and what is not posted. And so when censorship takes place, they become a publisher and not a platform. and should therefore not be should not be protected by the liability protections that they're granted. So while this bill seeks to accomplish the purpose of preventing censorship, I don't see how we can actually enforce this. It would be very, very difficult at best to do that. However, I think even in ITLing the bill, we can send a very strong statement to these social media platforms that platforms is reminding them that they are platforms and not publishers, and that censorship is not, it should not be tolerated.
Right. Other people wish to, yes, Representative Horrigan, please.
Well, I'm certainly a very huge free speech and freedom of the press advocate. Well, first of all, of course, it's not freedom of the press includes the option to not print things you don't want to print. So, like, it's if I post something on Twitter or Facebook, it's not my press, it's their press, and they have to do a certain amount of content moderation. You can call it censorship. First of all, there's a lot of stuff that some people want to post, which nobody wants to see. Nobody wants to see work from home scams or just incoherent Nazi rants or or that sort of. There's all kinds of things that people are going to try to post on any platform, which will just clutter up the platform, and also even in terms of political debate, and maybe that's kind of an unfortunate thing in some ways, but they're in the business of they're basically in the business. They're providing these services for free in exchange for us being exposed to some advertising now and then, and people aren't going to log on to the service unless it's stuff that they enjoy reading, not necessarily just stuff that they agree with. It wouldn't be fun to see a social media site where everybody agreed with me, but it has to be, if it's not within certain parameters that I'm willing to look at, I'm not going to log on the site. Nobody else is going to log on to the site. So to some extent, we have to respect their business model, and also the market will correct it somewhat. Sites that aren't interesting to read, sites that are offensive to read, people will migrate away from them and go to other sites, and then they also come and go anyway over the course of time, just because of natural evolution. Like, one time AOL and CompuServe dominated the social media space, and now AOL kind of exists, but CompuServe doesn't exist, and I'm sure the same will happen eventually to Facebook and Twitter and the like. So new platforms do come and go. So their monopoly power is not. I mean, it can be troubling sometimes, but especially in the case of Twitter, we had an eccentric billionaire bought it, and I really don't exactly understand what he's up to half the time. But I think I think the concern behind this bill is exaggerated. The marketplace will correct it eventually, and also, of course, this is a federal issue, so we have very limited purview over this. So the only thing this might accomplish would be for social media services to start redlining users they believe are from New Hampshire, and that would certainly not be good, especially if we want to keep our first in the nation primaries. So I would agree for slightly different reasons that we should ITL this bill. And thanks.
Yes, Representative Tur.
Yeah, just one other point that I think is worth making sure we draw out is during the testimony in section 359 U4, it basically came out that anyone essentially who has any interaction with anyone in social media that touches New Hampshire would have potential standing for this, which could open up New Hampshire as the grounds where all cases of social media, because this doesn't exist elsewhere, would be viably heard no matter where you lived in the world. And related was the question of needing these social media platforms to then collect information about where you physically were at a given time. And both of those, I think, are really difficult issues to overcome.
Anyone else? So I guess I have to say that I'm going to vote for this motion, and I support it. But I am torn about this, because I do think it's really unfortunate that there's been that the social media platforms have chosen to sort of behave in the, for lack of a better term, sort of woke manner that many of them have. But I'm concerned that the medicine may be, the cure may be worse than the disease, and in particular, I'm really worried about what the implications would be about holding some of, Google or Twitter or the Facebook, whatever, to be public utilities. I'm not quite sure that the analogy between that and, EverSource or AT&T holds, and I'm concerned that there would be other implications that frankly, those of us who believe in kind of limited government and let the free market do its thing would not be happy with. So that, on balance, that's why I come out to support the ITL. And I have to note, as I think a couple of people have pointed out, but just to give you an example, this bill proposes to protect free speech on these platforms. But then if you look at section U43, and I'm quoting here, this chapter does not prohibit an interactive computer service social media platform from merely providing expression to a user in a particular instance in response to that user's express request in that particular instance for expression limited on the basis of viewpoint or geographic location. I'm not quite sure I know what that means, but it would seem to me that that would allow, you could drive a lot of Mack trucks through that exception, and which I think kind of shows that this is problematic. So anyway, enough on that, but that's why I'm gonna vote in favor of the ITL motion. Anyone else have anything to say? All right. Are you ready for the question? All right. Then the motion before the body is ITL on HB 320. And I would ask the clerk to please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez, Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page, Rep. Brennan,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer.
Yes.
Motion passes Chairman Lynn, sorry.
That's all right. Yes.
Motion passes 19-0.
All right. And any reason that cannot go on consent?
None.
All right. All right. Next, we'll turn to HB 171 FN, and the chair recognizes Representative Alexander for a motion.
Thank you, Mr. Chair. I move HB 171 in expedient to legislate.
I'm going to second that motion. Is there, Representative Alexander, would you like to speak to that?
Yes,
please?
thank you, Mr. Chair. The bill would change definition by adding a requirement. I'm reading from the fiscal note. Employer officials' decisions or omissions be discretionary rather than ministerial. This opens up more lawsuits for ministerial functions, which would expand liability for our state and local governments. I see no reason to expand the liability right at this time. I think the bill is formatted also incorrect, like not in a good way. So I just hope that the committee would join me in ITLing this bill. I think there are other bills that the committee will look at as well that have to do with the same subject area. So with that, I hope you join me in ITL.
All right. Anyone else wish to speak to HB 171? All right. Are we ready for the question then? On House Bill 171, on the motion of inexpedient to legislate, I would ask the clerk to please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Tripp, Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan, Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page, Rep. Brennan,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes 19-0.
All right. And again, any reason that that cannot go on consent? Seeing none, we'll put it on consent. Next, we turn to HB 314 FN, relative to the expectation of privacy in the collection and use of personal information. And I'm going to recognize myself and with a motion to retain. Is there a second?
I'll second that, Mr. Chair.
Motion's been made and seconded. Let me explain the basis of this motion. I think this is really an important bill, and I really want to recognize Representative Erfs for his work on this. He's done a lot of work on it, and I've tried to work. I worked with him on this, and I had proposed, which I think you've seen. I proposed an amendment which I know he and I disagreed on. I thought it was necessary to sort of to restrict the potential reach of the bill. But after discussions with him and after discussions with the former representative Kirk from, sorry, thank you, former Representative Kirk from Ware, I think that there are, I hope that we will be able to move forward with this legislation and hopefully in a bipartisan way next session. But I think there are issues that need to be resolved, and it needs to be tightened up more than it is right now. For example, one of the big issues that that Representative Erf and I talked about, and I think we may have talked about a little, may have been raised a little bit at the hearing, is it's one thing to restrict the government's ability to get and maybe release to other people private information. It's another thing if you're talking about private to create a right of privacy in our information when it's in the hands of a third party that's not the government, and what the potential implications of that could be to industry. I mean, we heard some people testify about their real concerns about what the implications of that would be for industry. But let me just draw, and I think there was reference made to this at the hearing, I believe. Let me just draw this analogy, or not, which may not be great, but I think it makes the point. In New Hampshire, the New Hampshire Supreme Court has held that there's an expectation of privacy in your trash. So if you fill up your trash bag, you put it out at the curb. The government, the police, cannot just go and open up, go sniffing through your trash bag and say, look what we found here. This is a drug proceeds ledger or whatever. They can't do that. They got to get a warrant if they want to do it. But that doesn't mean that if you're the neighbor of the person, or you're, a homeless person that happens to be walking down the street, that you can't open up that bag. And if you did, that you could be held liable. There's no law that I'm aware of that would say that, that if that happened, your neighbor comes in and opens up something that you've put out in the trash, that you can sue your neighbor and collect, and get an injunction or collect damages or something like that. I mean, if you could do that, it certainly wouldn't be based on any kind of constitutional provision. And so I guess what I'm really saying is we need to think really carefully about this. I hope we'll have more time to do that over the summer and be able to come back with a bill that will be tighter and will be able to draw bipartisan support, because I think that I think we all have an interest in protecting privacy. So that's all I have to say. Representative Smith.
Thank you very much, Mr. Chairman. I don't think we all have an interest in protecting privacy, so I'm sorry to disagree with you on that. I have an interest in protecting privacy, and I think many others do. Because we are going to retain this bill, I don't feel the need to go through all my reasons why. I think this is a very important bill. I think we are a state that has had a long tradition of being libertarian in terms of keeping the government out of private business, and I feel very strongly about that. I support your recommendation of retain and hope we will have some detailed conversations about this in the next few months so that we can end up with a strong bill that could pass the House overwhelmingly. Thank you.
Anyone else wish to? Yes, Representative Alexander.
Thank you, Mr. Chair, and I would like to echo my friend from Durham. I think she's entirely correct. We worked last term on a bill in a work session. I'd like to continue that tradition to try to make this the best bill possible. My concerns with this bill as is an individual shall have a reasonable expectation of privacy and personal information. I see that as private entities made the argument that there was no distinction between private and public, even though later in the bill it did concede that it's only public information in 507H3, line 26, 27, page 2. And the other concern I have is when a public entity shares private information, there's no standard of negligence, and I'd like to see that negligence standard in the bill in some way. So with that, I absolutely would like to retain this, and I'm happy to spend the summer months with Representative Smith and hopefully work on this. Thanks.
Anyone else wish to speak? Right. That's a very good point, Representative Alexander. The standard, the culpability standard. I think that's something that was missing, and I'm glad you pointed that out. All right. So we're ready for a vote. All right. So on HB 314 FN, the motion on the floor is to retain, and I'd ask the clerk to call the roll, please.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Tripp, Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page, Rep. Brennan,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes 19-0.
And so I should say, one thing I learned yesterday that I didn't realize is when we retain a bill, it doesn't go on the calendar because what it means is it stays in committee. So we'll have it. We'll have a meeting in the fall. We'll have to decide, what recommendations we might make for legislation for next term, but it doesn't go on the calendar for when it's a retained. All right. And I didn't know that until yesterday. I'm going to turn to HB 149 FN relative. Oh, I'm sorry. Yeah. No, go ahead.
I'd like to make a motion on this.
Oh, okay. Hang on one second. Relative to handling of requests made under the right to know law, and I would recognize first Representative Alexander for a motion.
Thank you, Mr. Chair. I move to retain HB 149.
Is there a second?
I'll second it.
Right. Would you like to speak to that, Representative Alexander? And then
Yes.
I will obviously have Representative Smith speak.
Yes, Mr. Chair, and
Second,
I
Greason.
I don't want to speak for Representative Smith. I think I wholeheartedly support this bill. I think it's a great bill. I think it's important that we put reasonable timelines on government entities for right to know requests. I think this is a completely reasonable bill and a reasonable timeline. The concern I have is that we just recently, this committee supported a right to know ombudsman who took office, I believe, this week or last week. We haven't seen the rulings of the ombudsman. I think it's a very valuable position, much needed. But I think that a lot of the things in this bill can be solved by the ombudsman. So I think the thing that we should think about is time, and give the ombudsman time. And if the ombudsman hasn't addressed it by the time we deal with this in November, I would be willing to sit down with Representative Smith and hopefully we can amend or pass the bill as is. Thanks.
Representative Smith.
Thank you very much, Mr. Chair. I apologize for trying to make the motion, but since it was my bill, I thought that I might get the first stab at it. Nonetheless, you're the chair and I support what you did. And as you all know, I have great regard for my colleague from Goffstown. But with all due regard and respect and all those positive words, there's nothing in this bill that is immediately relevant to the ombudsman. In fact, a co-sponsor on this bill is the person who played the greatest role in this legislature in getting an ombudsman and still felt that this bill was necessary, and that, of course, is our colleague from Newmarket. We have seen again and again and again, and we have seen no indication of changing the minds of those people who are resistant to the concept of right to know. We have seen no change in their attitude that they can take as long as they would like and prolong as long as they would like their response. All this bill says is, okay, if you want to take a long time to respond, fine, but you must tell the complainant, it's not quite the right word, what's my right word, right, tell the how long it's going to be. And if every 30 days you have to say, well, yes, this is the progress I've made, or we haven't made any progress and this is why. You can go on and on and on and on, but at least you have a responsibility to the public to tell the public why you haven't yet complied with the laws of right to know. And so I think that we can delay this, we can retain it, but that means all those people who have filed right to know requests and are not getting responses from some public agencies. There are many public agencies that do the right thing, but there's some that don't. And meanwhile, they're not going to get helped. And I would hope the committee in due course would vote down, retain, and would entertain an ought to pass motion. Thank you.
Yes, Representative Greason.
Thank you, Mr. Chair. I think everybody's in agreement that we need to address the issue of government entities not providing the records that are requested and doing it in a timely manner. One of the issues I found in this particular bill is that there's no actual requirement to provide any records. You can delay it 30 days, you could delay it 30 days, you could delay it 30 days, and as long as I tell you I'm going to delay it 30 days, I get 30 more days. And so I would actually like to see this bill modified to say not to exceed 90 days or some deadline, and then if you can't meet that, then there's some other course of action, either take it to the judge or take it to the ombudsman, whatever the case may be. But the fact that there's no actual requirement to produce the records, or there's no set deadline by which the records are actually going to be provided, I see that there being an issue with the current bill in its current state.
Anyone else that wishes to? Yes, Representative Andrews.
Thank you, Mr. Chair. I think the bill needs a little more work on it. There has to be a time frame. In the last 9 years, I have dealt with my school district asking for information off and on. And unless a person asks for something extensive that's really going to take a lot of research. There's no reason to keep going, well, I can't have it in 30 days, and then the end of 30 days, well, I got to have it another 30 days, because I think that's a disservice to the public. And I would, in this bill, I would really love to see some kind of reasonable time frame. Thank you.
Anyone? Yes, Representative Tur.
Yeah, just coming at it from a different perspective, but I think a reason to move it forward as it is almost the opposite of sort of the issues of stonewalling by local municipalities. I think the idea of reporting on the progress and reporting on the work that's going on in order to fill some of these requests, and I'm picking up on what Representative Stapleton said during the hearing, that there is also, people who put in very broad right to know requests that require a lot of time and legal review in order to fulfill. And I feel like this might help elicit or shine a light on the amount of effort that does go into some of these. So that's why I would support it.
Anyone else wish to be heard regarding HB 149? All right. So the motion on the floor is a motion to retain. Are we ready for the question? Yeah. Can I ask the clerk then to call the roll, please?
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews, Rep. Testerman,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez, Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
No.
Rep. Eaton,
No.
Rep. Page,
No.
Rep. Brennan,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Chairman Lynn.
Yes.
Ten to 9, motion passes.
All right. Okay. All right.
Oh, no, it's retained, it stays.
It's retained, right, right. So I'm gonna, I'm gonna turn, I'm gonna pass over 289 for the 254 at the moment, and turn to House Bill 289 relative to consultation with legal counsel under the right to know law. And I'm going to recognize myself and move ITL on that bill and ask if there's a second.
There is.
Motion has been made and seconded, and give me just 1 second while I turn to the bill. So basically, my reason for wanting to ITL this bill is I just think it is really completely unnecessary. What? Pardon? 289. I thought it was ITL on 289. 289. It's 289. Yeah. No, that's all right. No problem. So the reason I believe that ITL in this bill is appropriate is that I just don't think this bill is necessary. It suggests that we should add a proviso to the provision that allows there to be a non-public session to consult with counsel. And it goes on to say, provided under no circumstances shall a member of a public body retain or consult with counsel for the purpose of evading compliance with this chapter, and then creates a criminal penalty. It just seems to me that this is a solution in search of a problem. If an attorney were to do that now, the attorney would be subject to, I mean, assuming it could be proved, and of course that would be the proving that somehow a consultation with counsel was not really for a legitimate purpose would be, I think would be something of a fool's errand. But if that could happen, then the lawyer were somehow to participate in that, I think the lawyer would already be subject to disciplinary action by the bar. And there would be no, the public officials who did this for a non proper purpose would be subject to having the right to know law, their decision reversed by the court under the right to know law as it is now. So I just think that adding this language doesn't really do anything, and that's basically the reason for my ITL. Representative Horgan.
Well, I think I also would go further, and this bill appears to be totally unconstitutional since everybody has the right to counsel, even a public official who's suspected of trying to evade right to know law. In any case, the counsel's role would properly just be to advise them how to comply with the law, even though, of course, there's a lot of nuances on what's complying with the law and what isn't complying with the law. But yeah, you wouldn't be able to prove the counsel wasn't merely trying to advise his or her client on how to stay within the boundaries of the law, even if they're going very close to the boundaries of the law. So this, yeah.
All right. Any other comments on this bill? All right. Are we ready for a vote? Then on HB 289 FN, the motion on the floor is inexpedient to legislate, and I would ask the clerk to please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Kutab, yes. Rep. Perez.
Yes.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Brennan.
Yes.
Rep. Devine. Oh, you weren't here, sorry, when they
okay.
called. Okay. Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
18 to 0.
I
Oh,
think
sorry,
you have to call
Chairman
them.
Lynn, sorry.
Yes, that's all right.
So 19 to 0,
19 to
sorry.
0. Okay.
No, it's 19 because Stapleton's here now.
All right.
Stapleton was here
right.
and Devine was.
Fine, all right. And is there any reason that this cannot go on consent? Anybody object to it going on consent? All right, so it can go on consent. Next, I'm going to turn to HB 307, relative to attorney's fees in actions under the right to know law. And I would recognize Representative Perez for a motion.
Yes, I would like to make a motion to have this ought to pass.
Is there, we want to hear from you, but let me first ask if there is a second.
I second the motion.
All right, Representative Perez.
Fortunately for me, this is a very simple bill. Basically going back to giving people the right to, if a judgment is made in their favor, the right to have their attorney fees returned to them. So it's appears to me to be very reasonable, and it's not until a final judgment is rendered. So therefore, I'm in favor of ought to pass.
All right. Anyone else wish to speak to this bill? I'm just going to make a brief comment. I think we're pretty much, I think pretty much everyone agrees to this, and I do think it's an appropriate change. I'm particularly, I think Attorney Bissonette from the ACLU, who testified on the bill, I mean, I think his point was very well taken. That one of the things that this bill will accomplish is that it will sort of signal to public bodies that the default position, the presumptive position ought to be that materials are to be disclosed. Now, sure, there are reasons for not disclosing it in particular cases as specified in the statute, but that ought not to be the presumption that local officials or state officials start out with. I think he made a very good point on that, and I think this will help to change the mindset, it seems to me. And so, and plus, just on the merits, I think it's a fair change. So I strongly support ought to pass. Anybody else wish to comment? All right, are we ready for a vote? Then on HB 307 FN, the motion on the floor is ought to pass, and I would ask the clerk to call the roll, please.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Brennan,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes 20-0.
And is there,
It is a
this has
fiscal
got a
note.
fiscal note, so we
But is
can't
it more
put
than-
this.
It is indeterminate.
Well, I think we probably should not try and put this on consent because I think I'm going to get pushback from the clerk. So we'll put this on the regular calendar. All right. Next, I would like to turn to HB 321 FN. Hang on a second. Find it. All right. 321 FN relative to minutes from non-public sessions under the right to know law, and I recognize Representative Alexander.
Thank you, Mr. Chair. I move HB 321 ought to pass.
Second.
Representative Alexander, do you wish to speak to your motion?
Yes, this is a great bill, Mr. Chair. So last year we passed a bill that would require municipalities keep a list of minutes that are non-public and the date that those minutes were sealed. So all this bill would do would require that the public body review those minutes every 10 years and make a vote to determine whether those minutes should be unsealed or not. Because there's a date already on the list, it's a very simple bill that would actually, New Hampshire Municipal Association said it would have a negligible, if any, fiscal impact on municipalities. And I actually want to point out that this is, it's really great to hear in Judiciary when Right to Know New Hampshire and New Hampshire Municipal Association support and strongly support the same bill. So I would hope that my colleagues in a bipartisan way will pass this bill. Thanks.
Anyone else wish to speak on this bill? All right, are we ready for a vote? All right, then on HB 321 FN, the motion on the floor is ought to pass, and I would ask the clerk to please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page, Rep. Brennan,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes 20-0.
And again, I see that there's a FN on this. Let's say here.
But it's minimal, and in testimony it was minimal.
I think it's under like $5,000, Mr. Chair, or something like that. You don't have to put it on consent.
you say? Should we try putting it on consent? All right,
think
so
the
we'll
both
try.
cases
We'll put it on consent and see if I get yelled at. All right.
Either way,
Anybody should say, anybody object to putting it on consent?
No.
either way, finance has to look at it anyways.
I was under the
It's been a
impression,
few years since I've been yelled at. It's I That's right.
for some reason, I think, remember that the fiscal note's under 10,000.
I think, no, you're
I
right.
think it can go on consent, so
Okay,
we
so
might
you-
be able to do that with
yeah.
307. It says indeterminate, but
All right. So you know what? Let me just ask. That's a good point. Let me just say: would anybody, if we could do it, and we will make inquiry, would anybody have a problem in putting 307 on consent if we can do it? No. Anybody have a problem with that? All right, we'll inquire, and if we can, we'll do it.
I'm gonna put it on consent and we'll hear about it later.
All right. Ask for forgiveness instead of permission. All right.
I live my life that way.
All right.
347, is that what?
Okay, I'm gonna turn next to HB 347, establishing a Superior Court land use docket. And I am going to recognize myself to make I have an amendment. The amendment is 2023-117H, and I would move the amendment. And is there a second?
Mr. Chair, I can second, or Representative Smith, if you'd like to.
I'm sorry, what?
Would you like to second that, or do you want to?
Of course, I'd be happy to say.
So if I may
Thank you.
speak to the motion, this bill would establish a Superior Court land use docket. The amendment in particular, let me just address that. During the hearing, you may recall, Representative Smith raised a couple of questions, very good points, that we needed, that the way the original bill was drafted, it said that there would be, the governor would appoint the first justice of the Superior Court land use docket. Didn't specifically say it had to be an additional judge, so to speak. So presumably, if there were a vacancy on the Superior Court under the original bill, the governor could have just filled that vacancy with an existing position. This bill changes that language to make it clear that it's an additional justice of the Superior Court. And in section 2 of the bill, it specifically indicates that the staffing of the Superior Court shall be increased from a Chief Justice and 21 justices to a Chief Justice and 22 Associate Justices. The other point that Representative Smith discussed with me, and it made sense to me, I didn't have any problem with it, was to add language on page 2, line 1. You'll see language has been added that says, nothing in this section shall affect the concurrent jurisdiction of the Housing Appeals Board to hear appeals within the jurisdiction, within its jurisdiction brought pursuant to RSA 679. So what I think that even if that language had not been included, the result would be the same, because nothing in this bill would propose to, outlaw or change the land use, the Housing Appeals Board. But it doesn't hurt to have that in there, and I therefore had no objection to when Representative Smith raised that, to including this in the language. So I think the amendment makes sense, and I think for the reasons that I stated at the hearing, that it does make sense to have a Superior Court land use docket. I have to say that I have heard an argument, not from anyone on this committee, but I've heard an argument from some people saying, no, this is a bad idea to have you'll notice that in the bill, it says that, the first judge of the land use docket has to be somebody who's, has experience in land use law and that kind of thing. They think somebody, said to me, that's a bad idea. So I can't help thinking, just thinking to myself, and I said to them, so is the idea that you would rather have somebody deciding land use cases who knows nothing about land use law? Or, I mean, is that a better way to go? I don't think so. These are, as I think you've heard at the hearing, these can be pretty complicated cases. And it does seem to me that it makes sense to have someone who has expertise in that area. And I would note by analogy to the Superior Court Business Court docket. That's been in effect now for over 10 years, probably 15 years. It's really been, the first justice appointed for that was Justice McNamara, had a great deal of familiarity in business law matters. And from everything that I've heard, he served until he reached the mandatory retirement age, and really did, I think, if you check among any members of the bar, I would say he really did a very excellent job in that. And that was and now, and Judge Anderson has taken over that docket. It was and is a success, and I think the land use docket would turn out to be the same way. So for that reason, I hope you will support the amendment and then support voting on the bill as amended. Yeah, so first anyone want to? Yes, Representative Perez.
I just have a quick question. This does not prohibit them from taking a justice who is there already, moving them to this where they have experience and then bringing someone else in, or does it?
No, I don't think it does. In other words, it just has to be, this has to give a new
Position,
justice,
a
and
new
the person who was chosen, even if it was an existing justice, would have to be someone who fits the definition of, having experience in that area. Any other questions? So I think this is on the amendment. I think we can vote by a voice vote, unless anybody wants to have it be a show of hands or a roll call. Seeing none, I'll call the question. All those in favor of Amendment 117H to House Bill 347, please say aye. Aye. Any opposed? Hearing nothing. All right, and we then now move to the main bill of ought to pass on HB 347 as amended. Any further discussion on that? Yes, Representative Andrews.
Thank you, Mr. Chairman. What I have to say, Bob Lynn, I told him the other day I was going to vote against this bill, and I have not changed my mind. In 2022, we had another bill, House Bill, 1389. It went to interim study. They had interim study. Last November, we voted in Judiciary not to go further with the bill. And what was written on it is the following: not recommended for future legislation. This bill provided for the establishment of a judge to decide land use cases within the existing structure of New Hampshire Superior's Court. While the idea of creating a specialized court to hear cases arising from municipal land use board decisions has some merit, the majority of the committee considered the present status of the New Hampshire Judicial Branch's caseload and the lack of the full complement of 21 Superior Court judges sitting on the bench, and determined that this initiative is not presently appropriate. In addition, it was suggested that targeted judicial training and the state's core land use principle may adequately address the concern which gave the rise to this bill. The vote was 14-5. My thing is this. For years, the legislature has made laws and told the towns within reason what you can do, what you can't do for your zoning, and they could make up their own policies, et cetera, et cetera. If all of that was good for years, what is our problem now? I really don't understand. As far as I'm concerned, we are taking the rights away from our local people. If they are making bad decisions, which anybody can, then they should receive appropriate training so these bad decisions don't continue. We also have the House Appeals Board. You can currently take a case to Superior Court. I think personally we are just adding another layer. Why are we singling out land use when in Superior Court, I believe there's a lot of other particular cases that maybe we should hire one judge and they take over those cases. Again, I'm going to vote no on this bill. Thank you.
Yes, Representative Alexander.
Thank you, Mr. Chair. I think this bill is a great bill. It sets up a separate land use docket that a judge with that particular expertise is able to evaluate land use decisions. It allows somebody that would like to appeal a ruling of a local board can go to the Housing Appeals Board now with this amendment language, or choose to go to the land use docket. This adds an extra judge, and that was the concern last year in Judiciary when we retained the bill, was we didn't have the resources to, at that time, as a second year, to appoint a new judge. Now we can do that. I think it gives them a great opportunity to pick where you'd like to appeal it. There's dockets for a number of issue areas. There's the family court. There's a bunch of different areas. I think by appointing one justice or one judge to this particular area, the reason why we need to do this, because there's a housing crisis, and let's allow the courts to evaluate each and every decision on their own merit, but allow the judge with that particular expertise to do it. Thank you.
Anyone else comments? Yes, Representative Perez.
Just for clarification, when was that study done? This past year? 2022. And then another question.
Yes.
Is it not my understanding, please correct me if I'm wrong, is the new budget financials, is that also putting forward to add an additional 5 justices as well?
No. Well, I'm sorry, Representative Smith. Go ahead.
First of all, we don't know the answer to that because we don't know until February 14th what the governor proposes to put in his budget. We do know that you have to look at the differences between the circuit court, which is very short, and the superior court, which is also short. What this language in this bill does is address only the Superior Court and says that there has to be an additional judge added to the roster that had been 21 and would go up to 22. When we vote on this bill, it will go to the House and it will then go to division if it passes, and I have every reason to believe it will pass, in part because of the identity of the prime sponsor. And we have to take that into account too. I'm serious. I mean, that is a factor. It will go to Division 1 of Finance. Division 1 has a lot of responsibilities, including the Judiciary. What they will likely do is hold this bill until they see what the governor has proposed in the budget, because they will not, I don't believe they will handle this separately. They will want to make sure that there is an additional Superior Court judge.
Yes, Representative Perez.
I'm sorry, so is it my understanding that specifically a judge for this particular need was addressed by this group, minus new people, last summer and was voted down, correct me if I'm wrong, was voted not to have, or down 14-5? Is that what I'm understanding from the information from Representative Andrus?
And if I could follow up on that, you're absolutely right. But circumstances change. Last time, if I remember correctly, there was no provision that said if this, and I'm sure Representative Alexander will correct me if I'm wrong, there was no language that said there had to be an additional judge. the concern of the Judiciary Committee in the previous term, and I believe the concern of the Judiciary Committee today, is that there are not enough judges to handle the caseload in the Superior and Circuit Courts in a manner that is timely, and we all know that justice delayed is justice denied. A key difference in this bill is not only that there would be someone who had specific knowledge, but that in order for this bill to be passed, there would have to be an additional judge added so that the caseload responsibilities would switch. And so that was, I think, a key difference. And because this is a budget year, whereas 2022 was not a budget year, there was no way to be able to add an additional justice to the Superior Court. And now the timing is that we have the possibility of adding a justice where we didn't have last year.
Representative Perez.
I'm sorry, the learning process. Did I not also hear that a study was done prior to that decision last fall about the caseload of justices?
There, well, no, that, I think I can answer that. So you need to, I think you need to understand we're talking about, there was a study done, but it was not just about the Superior Court. And that study was in process, but the study itself didn't come out until, I believe it was like last fall, and it was after the session. I think it came out in November or December of last year. It was a weighted caseload study, which shows that both the Superior and the Circuit Court need additional judgeships anyway, and particularly the situation is particularly acute in the Circuit Court, which is not what this deals with. I believe, and this was based upon a discussion I had with Chief Justice McDonald a while ago, so his thinking on this may have changed, but I believe there was going to be a request in the budget for the Circuit Court to increase the Circuit Court judgeships by 7, I believe, because there's a weighted case study, which is pretty complicated, but it kind of explains how many judges are needed in the bottom line, and that was what was shown to be needed in the Circuit Court. Now, with regard to, as I think Representative Smith alluded to, but with regard to, I think we should all understand, particularly the people who are new. If we pass this bill, it goes to finance. Finance, they're under no obligation to pass it just because we did, and they will consider the bigger picture, and they might, they not only the judicial branch but the whole budget. They're going to have to figure out what priorities for the whole budget. So they, I guess I'm hopeful that they will agree with us if we pass this, but it's, it'll be up to them to make another serious look at this in terms of the overall financial picture of the judicial branch and the state as a whole. Then they'll make their recommendation, and then eventually it will come back to the whole House to be voting on the budget.
If I could just
Yeah.
add one more point. Although nobody follows this, the reality is that this is a policy committee, and we are looking at the policy. Does it make sense to take cases related to land use and concentrate them? It is not our responsibility. We don't have to deal with whether or not there is enough money for this. We are establishing the policy. It then goes to finance, and the finance committee will tell you they don't do anything about policy. All they do is the money. And if you believe that, I have a bridge to sell you. Thank you.
So, just one final point I would make on this. Yeah, I think it's really important to understand that this bill, just like the Housing Appeals Board bill, and that Housing Appeals Board has been in effect for several years now, it makes no substantive changes to the law of land use. The law doesn't change at all by this bill or by the Housing Appeals Board bill. The substantive law of where you can build, what you can build, how much, what kind of a setback you have to have, how many units you can have, all that. Neither the Housing Appeals Board nor this bill makes any change to that. So that, the comment I made before, I think really is important, is this bill says it's a good idea to have a judge that's going to decide those things be a judge who has some knowledge in that area, as opposed to just you pick a judge out of the rotation, so to speak, who may have some knowledge. I'm not saying that no Superior Court judges have knowledge in this area. They do them now, and so they have some knowledge, but most of them probably don't have any expertise in this particular area. This says we would have a judge that does have that expertise. Yes, Representative Horgan.
But also isn't part of the rationale that this speeds up these cases. So
Exactly.
yeah.
Yes.
So you know, like whether this development proposal is going to fly or not sooner. Like,
No, that's absolutely.
not
That's an
necessarily
excellent
soon,
point.
but sooner.
Right. Excellent point. Yes, Representative Kuta.
I have the utmost respect for our chairman, but I also deeply value the opinions of my constituents, and the only constituents I've heard from had a lot of concerns about this, and so that's the reason for my vote, and just wanted to state that.
Yes, Representative Perez.
I apologize, but there are 21 Superior Court justices now, correct? Do you know how long that's been the established number, roughly?
It's been that way for it's when I first went on the court in 1992, there were 29. I became number 29, and that was. But then there was no family division then. The Superior Court handled family cases. Then, when the family division was established, the number of Superior Court judges went down significantly, and it has sort of come up rather slowly since then. So it's back to now 21.
Thank you.
Representative Tripp.
Thank you. It seems that a lot of people on this committee seem to think that the land use docket is only going to overturn the local land use board's decisions. I don't think that's entirely correct. I think that you probably find that a lot of the local land use board's decisions are upheld. And the local land use boards are interested in moving things along too. So that's why I believe this is a good bill, and I'll support it.
Any other comments? All right, are we ready for a vote? All right, then, on the main bill, we already having voted on the amendment on HB 347 OTP. The motion on the floor is OTPA, and I would ask the clerk to please call the roll.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Kutab. No. Rep. Perez.
No.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page. Rep. Brennan.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
16.
16 for regular calendar.
The motion passes 16-4.
All right, and it'll go on the regular calendar. All right.
240.
Gonna turn to HB 340, FN, relative to the transfer of residential property, and I recognize Representative Wallace for a motion.
I would move House Bill 340 FN inexpedient to legislate.
Is there a second?
I second.
All right, and Representative Wallace, would you like to speak to your motion?
Pretty simple. This is going to add a lot of regulation to real estate investors and whatnot, and require a lot of paperwork for transfer of real estate to a other than a natural person, and that's been a lot of business models or whatnot. People hold their real estate in LLCs or trusts. This is going to complicate things, and just not what we need to do at this point in time.
Anyone else wish to speak? I'm sorry, Representative Page, did you have your hand? Oh, I'm sorry. Okay. Anyone else wish to speak to HB 340? All right. Are we ready for a vote? All right. Then on HB 340, the motion before us is inexpedient to legislate, and I would ask the clerk please to call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Brennan,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes 20-0.
0. All right. And that,
So I
I
can
think,
go.
yeah, that can go on consent. All right. Then 379, requiring that attorneys be appointed to represent indigent tenants during residential eviction proceedings and making an appropriation therefore.
Mr. Chair,
Yes, do I have?
I'd like to make a motion that House Bill 379 FN ought to pass with Amendment 0219H.
All right. Is there a second?
I second it.
All right, seconded by, I'm sorry, who, second?
Manos.
Seconded by Representative Manos, all right? Representative Greason, do you wish to speak to your motion?
Thank you, Mr. Chair. In all of the discussions and all of the landlord-tenant bills that we have heard so far, the biggest issue has been really in communications. And this bill, in particular, in its original form, had way too many things to that I could not agree to. However, an amendment, what this amendment does is just simply put in the eviction notice that the tenant may contact the New Hampshire Legal Assistance for counsel, that they may be eligible for legal counsel through the New Hampshire Legal Assistance. There's no, and then of course a statement that says by calling whatever the phone number happens to be. It would be similar to if you're addicted to gambling, you hear all the disclaimers for the lottery and stuff like that. If you're addicted to gambling, call 1-800-I'm-addicted or whatever the number happens to be, or akin to the suicide hotline on the back of a student ID card, things along those lines. So it's just informing the tenant that they may be eligible for legal assistance.
Representative Greason, my only concern, I thought that when we had talked about this, that you had, that the amendment said something about the eviction notice shall clearly state that the tenant may be entitled, may be entitled to New Hampshire legal assistance. I guess what I'm concerned about is it doesn't quite say that. It sort of says may contact New Hampshire legal assistance. And my only question is, is this in any way, sending sort of an unfair signal to a prospective tenant that they have some kind of a right to counsel? I'm not, because I assume none of us, I assume you did not mean to say that they have a right to have an attorney.
No, this is not conveying a particular right to counsel, but that they may contact New Hampshire legal assistance if they're eligible, if they're qualified. I don't know what the requirements are. I don't know who can and cannot use it, what any financial requirements or anything along those lines. It's just merely stating that they may contact them. After that, that's the only obligation, is just the statement in the eviction notice And if the tenant then decides to call, that they may call.
Representative Alexander, I'm wondering if you have any, since you are on this housing committee, if you have any view on this?
Well, I would also refer to my friend Representative DiLorenzo, but I think this bill was a mess to begin with, but I think that this is a simple amendment that I think is a very, 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 very small bite of the apple.
So let me just ask, I'm sorry, Representative DiLorenzo, yeah.
Thank you, Mr. Chair. I think the purpose of the amendment is great. So I think of it as sort of like a public service announcement, but I would like to see the language tightened up a little bit.
Particularly the word guidance.
Okay.
Mr. Chair, are we allowed to hold off on this and maybe?
Pardon?
Are we allowed to hold off on this? This is not an early bill, correct?
This is not, well, no, it is an early bill. I'm sorry, it is an early bill. 379 is an early bill. So let me just say this. I guess what I would say is, yes, Representative Smith.
Mr. Chair, isn't it an early bill because of the original language in the bill? And all of that language relating to finance has been removed.
Right, if the, so if, yeah, my only concern would be if let's suppose that we put it off and some, at the end, we didn't adopt this amendment, then that would leave the original bill, which does have that time limitation. That's my concern.
I think it's a legitimate concern. I don't think there's any possibility that the original bill would pass.
Well, you know what? Let me just ask this question. Maybe maybe this is the lawyer being overly picky about some language. Let me just ask you this. I understand Representative Greason to say that this language is not in any way intended to suggest that tenant-facing eviction has some right to an attorney from legal assistance or otherwise, or even eligibility. They may be eligible, they may not. I can accept that understanding, and I guess what I would say is, does everyone else on the committee agree that this is not in any way intended to create some right to an attorney that doesn't already exist?
Mr. Chair, I agree that it does not create a right, but I'm also thinking of the calendar. We have already scheduled an executive session for next Wednesday. Today is Wednesday, isn't it? All day. It's before noon. We can add to next Wednesday's executive session. If you really feel that you want another amendment, we could add it to next Wednesday's schedule, take it up first thing.
All right.
And I think I don't think it's necessary. And I think you might want to remember that this is the legislative branch, not the judicial branch. But if for some reason you have a problem, I just don't see why we can't go ahead with this.
All right, Representative Kuto.
When I did my clerk training, it was mentioned that during situations like this, if somebody's willing to run down to OLS, sometimes they can fix this right up immediately and give us an amendment, and then we could vote on it. So perhaps we could, recess this for a few minutes, and maybe Rep. Reed, since she's here, might be willing to run on down for us.
That sounds like a very good idea.
Excellent.
I think that's possible and totally okay, but I also don't think it's needed because eviction notices don't appear in the RSA as is. It's always left to the courts to determine how they put it on the eviction notice. So I think we need to adopt the amendment, but once the amendment's adopted, we leave it to the courts to make that decision on what goes on the eviction notice anyways, and that's typically been the procedure for all of this stuff.
Right. No, I mean, well, that's true, but I guess my concern is that this statute will be in the law. I mean, it will be on the books. So yes, Representative Horgan.
Thank you. I think even if we passed something like this that wouldn't have been a early bill if we passed it originally, I think we now still have to send it to finance. I speak from a personal experience I had. Of course, that was 2020 during the pandemic hit during the middle of the process, so everything was a little bit topsy-turvy. But I had a bill in education that would have cost a significant amount of money, hence was an early bill, and would have gone to finance, but they turned it into a study committee, but it still got heard by finance. Although I guess the finance chair could have waived the reference and then just sent it straight on to the body on the other side of the wall we're not allowed to talk about. But I think we still have, I think regardless of whether or not there's a fiscal impact, we still have to like meet the deadline for the early bill, and it still at least might have to go to finance. Thanks.
And if I could just add one more thing, Mr. Chair, if we could accept this, maybe I'm just trying to adopt the KISS principle, which my children keep on trying, kept on trying to tell me to do. I never agreed, but in this case, we know that the bill, it would appear, has to go to finance, and finance might refuse it, which would be great. It would then go to the Senate, and if we need to fine tune something, we can fine tune it in the Senate. Representative Greason could go to the Senate and say, you might want to clarify this language. So I would urge us to accept this amendment if it passes, and accept the bill, keep it on the schedule that it's on, perhaps suggest to Representative Wheeler that he really doesn't want this bill, but if he does, he'll take it. And then eventually it would end up in the Senate. And so there are lots of opportunities to fine tune it. And there's even one more, and that is that the committee could suggest a floor amendment if we feel that we want to, between now and when it gets to the floor, if we want to tighten the language. So I would urge us to go ahead now, get it off our books. We have so many other bills that we're dealing with, and we have lots of opportunities. We have the Finance Committee. No, first we have the floor amendment, we have a Finance Committee, and we have the Senate if we need to fine tune it anymore.
May I?
Yes, Representative Kuta.
In light of the fact that we still have two more bills, I'm wondering if we could just hold off on this for a few minutes and see if they could. I do agree it is a bit ambiguous, and I know other committees also have a large number of bills, and so I don't want it to get kicked back just because of that. If we could just see if it might be possible to change it right now, and if it's not, then perhaps consider Rep. Smith's idea.
So let me just ask, I think that makes sense to me. Let me just ask you this. Here's what I suggest, in some quick wordsmithing, but I think it accomplishes what at least would satisfy me. Suppose we change the language starting on line 10 of the amendment so that it would read, the eviction notice shall clearly state that an indigent tenant may be eligible for assistance from New Hampshire Legal Assistance you can take out the word maybe eligible for assistance from New Hampshire Legal Assistance for the eviction proceeding, and include instructions on the process for obtaining such assistance. Or maybe eligible for assistance from New Hampshire Legal Assistance.
Process for contacting such counsel.
Maybe eligible for.
Mr. Chair, could
Yep.
I suggest that we put this bill aside at the moment. We asked someone in the room who might be willing to run quickly down to OLS with an amendment that would come in under whose name? It can't come in her name. It has to come under Alexander's name, and stand there until they actually do it and bring it back to us.
Do you need me to send an email to OLS? I'll do that. I'll be like, do whatever Representative Reed says.
And
That's
then we can
concerning.
vote, and we can then have two choices, okay?
Well, I do
Oh,
believe
yeah.
we need to have some boilerplate in it. This is not to be misunderstood to convey any.
It can be a Judiciary Committee amendment, but if they need a name, use Alexander.
So, wait, hang on, wait a minute, don't go yet. Yeah.
Did we take out Part B of establishing a non-lapsing?
We took out
Yeah, we
all
took
of
out
that.
everything.
All that is
I missed
gone.
it. My other question is, during judiciary government said it needed structure, but the other thing we mentioned during testimony was putting in that they had to do mediation first. We talked about that, but we've tried to kind of let that go, if that's any concern.
I don't think
I think that wasn't set up for all the counties yet, unfortunately. They were trying to expand that.
Yeah, thank you.
All right, wait, so Representative Reed, hang on one second here. I'm sorry. I'm going to give you this. So let me start again. Tell me if everyone is all right with this. The eviction notice shall clearly state that an indigent tenant, comma, although having no right to counsel, comma, may be eligible for legal assistance from New Hampshire Legal Assistance for the eviction proceeding, and include instructions on the process for obtaining such assistance.
Could
Everybody-
you change representation to assistance so you don't have assistance twice? Is that
Oh,
what-
for such representation, yes, that's fine. All right. Hang on, I'm gonna give you this so you can, can you read my chicken scratch?
You're gonna sign it, Mr. Chair?
Okay. The eviction notice shall clearly say that indigent tenant, although having no right to counsel, may be eligible for
Representation.
assistance from New Hampshire Legal Assistance or the eviction.
Representation.
May be eligible for legal assistance
Legal assistance.
from,
Is that-
New Hampshire Legal Assistance for the eviction proceeding, and include instructions on the process for obtaining such
Who knew
representation.
this was gonna be so interesting?
Mr.
Is that all
Chair,
right? She said representation is
Yeah,
there.
no, that's fine. I put representation at the end.
Thank you.
Wait, hang on, don't leave yet.
I
I'm
was,
leaving my purse here. I can't think. Put it right here.
I was just going to say that on hearing it verbally, it strikes me as conveying to a tenant, an indigent tenant, you have no right, but you may be eligible. I would rather see it, although having no right, left out, and then a final concluding sentence, this does not establish a right.
No guaranteed right? Or this does not establish a right?
See, you know,
This does not establish. a
I,
right?
no, you know what, you know what, I see your point, and I might even agree with you, but we're, rather than sort of leave Representative Reed dangling, the more I think about this, the more I'm thinking that Representative Smith's suggestion that we just put this off, deal with it first thing on next week, as the first item for our, on agenda for next week, it seems like everybody's sort of on board with the idea that we just need to wordsmith it, but everybody's in agreement that we should do it. Is that sort of right? Yes, Representative Stapleton.
I'm not comfortable with has no right to counsel. I think that sends a wrong message, and indigent people who don't understand the law might feel affronted by that. I think you can leave that out and still accomplish it. I mean, I just wrote down, be eligible for assistance from New Hampshire Legal Assistance upon request. Doesn't say who makes the request, but makes it simple and direct.
Interesting, maybe.
I can't go with the has no right to counsel. That doesn't sit well.
Okay. All right. Well, then my whole purpose for wanting to change the language was a concern that somehow this doesn't, the language that's used doesn't create an argument in some lawyer's mind that, oh, wait a minute, they said in here that, you have the right, you may be eligible, but at least that suggests that they should go there, and if they really are indigent, then they are eligible. That would be my concern.
Well, then you'd have to go to the analysis. The first sentence, the bill provides that an indigent tenant shall have the right to counsel. So one place we say they do, and then
Right, but this
and
section.
then we say no right to counsel. I mean, both of those have to be reconciled.
The amended analysis.
Right. The amendment sort of completely eliminates 379. So I don't know, as I've heard the discussion, I think we would be, in other words, I think it would be better to just, hold off until, next week, and we'll get some language we'll get some input from yeah, I'd rather have you not do that, and we'll, and or yeah, would you, and you know what, and I don't have can you just make a copy of what I gave you so I get it back, because I don't have another copy of it. That'd be great. All right, so I would then propose that we hold off on this bill until, on HB 379 until, next Wednesday, and we'll take it up as the first item next Wednesday. Great, thank you.
Then
First,
could you tell, Karen before noon that
on, 2/8/23. All right. And then, you know what, I think it might be a good time to just take a seventh inning stretch. Does that sound good, for a few minutes? Thank you. All right. All right, I'm gonna call the committee back to order, please. All right, so we left off, we're gonna make some quick changes on two. Oh, yes, we do. We need Representative Testerman. And, yeah, and we need Representative Durr, yep. Where's Testerman? What's it? Where's Testerman?
I have no problem with drawing conclusions.
Okay.
I get it. Okay, all right.
No, I think the trick is that bottom drawer.
Yeah.
Put
All right.
that one in with your foot.
All right.
There is a safety interlock, so that you can't open more than one drive.
So I wonder, could go ahead and make this? Okay. Are you feel confident with that? Oh, okay. Maybe this is, no?
Yes.
Ah, there we go. Okay, all right. All right. All right. I think we've got everybody back. So I'm going to call the committee back to order, and just to recap on HB 379 FN, we're going to take that up the first thing next Wednesday, and since we're going to start at 11 o'clock on Wednesday, presumably we'll have the language all set to go. It'll be, we'll go right through it very quickly and and I'll have a report written by that time, so we can just get it, so it goes to, we don't get over the deadline of getting it in the calendar. We'll make that happen. All right. So now I think we're done except for two bills, and I'm going to turn to HB 254 and recognize Representative Wallace for a motion.
I would move House Bill 254 and expedient to legislate.
Is there a second?
I second.
All right, Representative Wallace, do you wish to speak to?
Briefly, thank you. As this bill addresses local boards within a town or a particular district, they're, by definition, they're close by. There really shouldn't be any need to do this stuff remotely. People run for the office knowing there's going to be a bit of a time commitment, a couple of days a week in town. So let's get to the town meeting office and let's get these held in person. That's the way it needs to be done. Thank you.
Anyone else wish to be heard? Representative Alexander.
Thank you, Mr. Chair. I would like to point out current RSA provides for the ability to attend and vote remotely in special situations. For instance, in Goffstown, we had necessary warrant articles that need to be voted on, and we had a selectman that was traveling for business. He was allowed to vote remotely so he could have his vote appear on the town warrant. So there's already RSA that provides for situations provides for this specific situation. So this bill is just not needed.
Representative Page.
Thank you, Mr. Chair. I'll be voting against the motion for ITL and let folks know that I would propose an amendment that I distributed through email and hard copy to this bipartisan bill that I think addresses this concerns that were raised at hearing relative to preserving some of the bodies that already do meet or have the option to meet remotely, and then so that would be my position on this, that this COVID allows local public bodies to do that. We've clarified the term in the amendment to exclude town meeting. So I think that I will be voting against this, and would like the committee to entertain an amendment that I think address the concerns that we heard at hearing. So thank you very much.
Anyone else wish to be heard on? Yes, Representative Perez.
Does this exclude, I know it excludes town meetings, but it doesn't exclude school meetings, correct? Because we have a town deliberative and a school deliberative. And our form of government is separate town from school. So therefore, I feel concerns that school isn't included in this.
Representative Smith, I believe you wish.
Yes, I don't want to respond to Representative Perez's question.
Oh, Representative Page, if somebody else have a, oh, Representative Testerman, I'm sorry, did you have something?
Thank you. I know that we've become quite enamored with remote meetings at almost every level. I almost 100% don't participate in them because I believe the kind of government that we have here in New England that had a requirement to get everybody in attendance that wanted to participate was the best way to do it. And I think now that we're trying just to pick off all these various things, onesie twosie, and I'm against it.
Thank you, Representative Smith, did you wish to speak?
Yes, thank you. I hear what Representative Testerman says, and at some levels, I'm quite sympathetic to that. I live in an SB2 town, which no longer has town meetings, and I find it very sad because very few people show up at the meeting to hear to discuss possible amendments or whatever. They show up only to vote, and they don't necessarily know what they're voting on. I think it's important for people to participate physically and as I say, miss the town meeting approach. However, with all the negatives that came from COVID, we have found in many arenas that a lot more people pay attention if they can be sitting at home and watching. We see that here in the legislature when you look at how many people sign up to say they're supporting or opposing a particular bill. And the more people who do that, the better. In this case, we're not just talking about the observers, so to speak. We're talking about the decision makers. And I think it's good to have people in the room and to be able to see how they're reacting and to be able to respond quickly. But I also think that what this bill does is look at situations where we have been able to involve more people in the decision-making process by having them participate remotely. And it is not mandatory. As I understand it, and perhaps I'm wrong, it is still up to the local jurisdiction to decide how they want to handle it. And some local jurisdictions will say no. But the ones that want to say yes, I think, deserve the right to do that. And so while I would like to have everybody participate in person, I am going to be supporting House Bill 254.
Anyone else wish to speak? Representative Manos.
Thank you, Mr. Chair. I just wanted to address Representative Perez's concern by pointing out that under the amendment, specifically school meetings and town meetings are excluded, are exempted. And so I think the amendment addresses her specific concern.
All right. Representative Perez.
I'm sorry, I have one more concern. If I call in on the phone to be part of a meeting, how do you know it's me? How do you know it's me? How do I know that well, it couldn't be you, but because you're a man and they'd know. Representative Devine wasn't calling in my town or someplace on a meeting to represent me. I think if they had to be, seeing somebody is entirely different than hearing from somebody. I was involved in a long case with speaking to a judge in Arizona and lawyers, and I had no idea who they were at all. I think it opens Pandora's box. So
All right, and Representative Stapleton.
If, as I mentioned before, that in the Sullivan County delegation, we have sometimes one or two people who on travel or illness can't make the meeting, but we want their valued input. And so we have a screen, and for the most part, there's visibility there as well as audio for the person speaking. If they don't have the camera capability, then we have the voice, which we recognize and or is validated that that's the right number, the right person connected to it, by the chair. My attitude is the bill is unnecessary because if it's not already prohibited by law and not illegal, we already have the right, and leaving it up to the discretion of the local instrumentality or authority makes sense under our live free or die concept.
Anyone else wish to speak on Representative Horrigan?
Another factor why the remote meetings prove useful is that in many communities, the school is the only facility that's suitable for holding a public meeting. And even when it's not, you have the school board would prefer to meet. Like in Durham, we do have a very nice town hall, but the school board prefers to meet at the school, and that creates certain issues. Well, there's federal gun law, and then there's certain members of the community who wish to participate in the meeting who either cannot, well, in some cases they don't feel they can ever take their gun off, but at least they certainly would prefer not to take it off so they can participate at home where, you set your own gun laws. And conversely, when there's a respiratory disease, well, you have some people who don't want to go anywhere without the mask because they're afraid of catching disease. There's others who feel they cannot wear the mask for health reasons of their own. So those are, and I'm sure we'll have more respiratory epidemics. The COVID one wasn't the last one. So those are two situations where the remote meetings are very, very handy because so you don't have to worry about issues with people who cannot go to the specific venue where the meeting is being held. And of course you have the people who are disabled who can't travel easily. So that's like another good thing about expanding these remote meetings, and which were much better, which at least in my community were attended much better, I think, attended as well, or in many cases better than the traditional in-person meetings.
All right. Anyone else wish to speak on HB 254? Representative Andrews.
Thank you, Mr. Chairman. I am totally against remote meetings. When I became a legislator 2 years ago, it was in COVID, and everything was remote in the state, the county, the schools. I attended so many meetings, they were inaudible. You had no idea what was going on. One particular situation, there's actually two of them, I was supposed to be participating in the meeting. There was no way it was audible, and I just left. It might not have been the right thing to do. I think, like equipment, what are we going to demand that each place has for equipment? I mean, it depends on how good you can project what you're doing if you don't have appropriate equipment. I just feel it's too easy to sit home and do a remote, and there are many people that don't even have access to computers or anything like that and might want to do something in person. I just feel we're also opening up a can of worms or Pandora's box, whatever you want to call it. And there's going to be a lot of issues that we cannot take care of. Thank you.
Anyone? Yes, Representative Manos.
I just wanted to also add that under the bill, a quorum of at least a third of the total membership of the public body would have to be present at the physical location of the meeting. And so there is a physical presence. It's not that, and that is required. And so there is a physical presence, and it's not that everyone would be participating by electronic means. So I think, given that the impracticalness of everyone attending, I think that this is a good and reasonable solution to the problem.
All right. Anyone else wish to be heard? Representative Greason.
Thank you, Mr. Chair. I think we are conflating a couple of different things. First of all, the general public, we broadcast the meetings to the general public. We are meeting in person, but it is being put out, and you can live stream it on YouTube. You could participate. You could sign up and voice your support. We are not taking any questions from anybody or comments from anybody via live stream. We don't have a screen up here where we could see anybody dial in. So that is a separate issue. The participation, getting people to participate in these meetings is a whole lot different than the body that is meeting, because they are the ones who have to hold the meeting. If the current bill allows only 1/3 of the members to be present to have a quorum, that means in a school board where there's only 3 members, one person draws the short straw to go in and turn all the equipment on and have a meeting in person by him or herself, while the other 2 can stay home and warm by the fire. I don't know how you can honestly transact the business at hand when only 1/3 of its members comprises a quorum.
Anyone else wish to speak to HB 254? Yes, Representative Brennan.
Thank you. Am I understanding correctly that we are still discussing the original bill and not the amended bill?
The there's been no the motion on the floor is to ITL the original bill. There's been no amendment has been presented on the floor because we're dealing with the ITL motion.
If I may?
Yes.
I'm looking at the amended version and I'm not quite sure exactly what has changed in the amended version, but I would like to point out that what I'm reading is that this is an enabling bill that would allow governing bodies to make the decision if they would allow for this remote participation from a member of the governing body to participate in their meetings. This is not a mandatory remote meeting bill. This is allowing. It says may allow. Additionally, a concern that was heard was that members would not be able to see, but it says explicitly here that each member participating electronically or otherwise shall be able to contemporaneously and throughout the meeting see and hear and be seen and heard by other members of the public body attending the meeting. Am I understanding it correctly that every member of the governing body would need to be seen and heard whether they are present in the meeting space or on the electronic communication?
Yes, Representative Kuta.
In the original bill, it doesn't say that. It says or, so the bill that we're talking about now does not say that.
Thank you for that clarification.
Representative Horgan, did you wish to say something?
Well, yes, I believe this, I can't remember, this bill or one of the others where the right to know spokesman made a big point of saying we have to be able to read the members' body language. And I'm not sure, I mean, obviously that's part of how we're communicating, but it seems to me we're primarily responsible for our words, and the body language is often be misconstrued. I remember many years ago, my first term, the chair of this committee happened to have a physical disability, so sometimes he twitches or he involuntarily appeared to be laughing, even though he was, and even though he was in fact a very respectful person, and his words were always carefully slogan. So, like, some people who didn't like what the committee doing were accusing him of laughing at them on the stand, when in fact that was, well, he does have sort of a wry sense of humor, but that was absolutely not what's happening. So, so I think, I don't know, I think it's something, I'm not, I think to some extent, some extent they were demanding it so they can read something into people's body language, which may or may not have been there. And although if you have a Zoom meeting or whatever, you can see people in their little frames, so sometimes you can sort of read more of their expressions than you can in person. So I think, I don't know, I'm kind of, now I've lost it. I think I may have drifted off topic here, but we are primarily responsible for our words, not for our body language. And also, this is also the purpose of any meeting is primarily so the members of the body can discuss the issue amongst themselves, and then when need be, have members of the public or other outside members. But the purpose of the meeting is primarily for discussion amongst the members of the body, rather than just to allow themselves to be scrutinized and confronted by, whoever random people are taking an interest in the committee for whatever reason. So thanks.
All right. Anyone else wish to speak on HB 254? All right. So the motion on the floor is ITL on House Bill 254. Are we ready for the question? All right. I would ask the clerk to please call the roll. ITL on 254.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Kutab. Yes. Rep. Perez.
Yes.
Rep. Smith. Rep. Horrigan.
No.
Rep. DiLorenzo.
No.
Rep. Eaton.
Yes.
Rep. Page.
No.
Rep. Brennan.
No.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
No.
Rep. Tur.
No.
The motion, sorry, Chairman Lynn.
Yes.
The motion passes 13-7.
ITL. All right. Okay. Hang on just 1 second. All right. All right. That will go on the regular calendar. Regular. All right. I'm going to now turn to HB 308, and I would recognize myself, since I did the amendment, for an amendment, which is amendment, I'm sorry, I moved, ought to pass on 340, and I offer amendment, I'm sorry, motion ought to pass on 308, and is there a second?
Second.
All right, and I offer now amendment 240H to 308, and is there a second on that?
I second it. Oh, okay. I'll let Manos do it.
I second it.
All right, and if I may speak to the motion, this motion, this amendment is designed to allow for remote meetings by state boards. It specifically excludes the general court or either house thereof or any committee of either house, and it also specifically excludes the governor and council. It applies to, however, all state agencies, boards, committees, councils, advisory committees, and the like. And I took that language out of other sections of the right to know law, the composition of which is permitted by law or regulation to be drawn from individuals who may reside throughout the state of New Hampshire. So this would apply, for example, to the advisory, Representative Page, you mentioned an advisory commission, was it disabilities?
Two, yeah. One is the Developmental Services Quality Council, which is established under RSA, and then there's a Special Education Advisory Council, if I have that right, the SAC, I think.
Right. So it might, I mean, it would cover those kind of statewide advisory councils. Yeah.
Thank you.
It's and it specifically permits remote meetings. It requires at least 1/3 of the total membership to be present. And you'll notice I did make a slight change in this language from what was used in some of the other, for example, the 254, and I think even the original version of 308. I think it would be problematic to say in the thing about 1/3. I think it would be problematic to say you have to have a quorum or 1/3, whichever is less, and then say later that a member participating remotely it qualifies for the quorum. Because if you worded it the way it was originally worded, at least an argument could be made that, well, wait a minute, all you have to have present is a quorum. We've defined quorum later on to be a person who's remote, and so at least there would be an argument. At least there would be a conflict. So I changed it to say at least 1/3. That just took that out. I think that this amendment makes sense. I understand that there are concerns about having remote meetings at all, and in many ways, I'm sympathetic to that. On the other hand, I think that Representative Upham Nutter pointed out that there are a number of, she was talking about the Rare Disease, I think, Advisory Council, that there are a number of these committees where they draw, it's a statewide committee, they draw people from around the state. So the travel issue is a lot more of a real issue than it would be in terms of local or county boards or commissions. And so I think that this makes sense to do this. And I hope that we'll get a bipartisan vote to support this, because I do think it makes sense. And although I appreciate Representative Nutter Upham's concern in particular about the disabilities, the Rare Disease Advisory Council, I don't think, and I hope that the majority of you will agree, that it doesn't make sense to pick out one particular board. It makes more sense to just have a kind of a generally applicable provision. So with that, I hope you will support this amendment. Representative Horrigan.
Thank you. I happen to belong to it's a Vital Records Privacy Board, which is a joint under the aegis of Health and Human Services and the Secretary of State's office, and they meet in the same. They actually meet in the same facility where I believe the Rare Disease Board would meet if it had ever had an in-person meeting in the last couple of years, and that's in a secure area of the HHS's offices on Hazen Drive. So it's in a small conference room that has fairly robust teleconferencing facilities, and they often have a variety of meetings there, many of which are confidential. So it isn't really practical to have a large group of the public in that small conference room, although they do have a auditorium and other spaces they could use if for some reason a large number of people from the general public showed up. Usually nobody shows up. In the case of my board, I think maybe they're doing a little bit of security by obscurity. I'm not even sure exactly where you would go to find out that it exists. But so as a practical matter, the Rare Disease Conference is one of a number of bodies, some of which are in groups, some of which are covered by, this law, some of which are, just ad hoc groups within HHS who really it isn't necessarily practical for them to meet in the auditorium except in rare occasions, and so it's more practical for them to meet securely through their well-established teleconferencing facilities, which work pretty well. I've participated in board meetings both in person and remotely, and the experience has been good either way. So that's just my 2 cents on it, and that was probably explaining what the original impetus for the bill was. So, and it applies not just to that committee, but to a number of other committees. So I think they should be they should be allowed to meet remotely in most cases. Thanks.
Anyone else wish to speak on this amendment to House Bill 308? Representative Stapleton.
Thank you, Mr. Chair. The ability to have a remote person help constitute quorum is really helpful and avoids the inefficiency of not being able to do business at a meeting for those that have physically gathered. And, you know, we're getting into situations, illness, travel, a disability, weather. And so I think this is an important provision. And we protect it by having a roll call vote in the case of having a remote person attending. So I'm in favor of it.
Right. Anyone else wish to speak on the amendment to HB 308? So this is an amendment. We can vote by voice vote or unless somebody wants to have a roll call. Yes. All right. There's been a request for a roll. Yeah. All right. So we'll have a roll call vote then on the amendment. Representative Andrews, I didn't mean to cut you off. I apologize.
Thank you, Mr. Chair. Again, I'm going to vote against this. I do not believe in remote meetings. I understand what everybody says. I'm not hard-hearted by any means. But when you take an office or you go on a committee, you know right then and there you need to show up. And if you don't show up or you feel that you're not going to, you should not say yes to being on a committee or anything. I mean, that's all I've got to say. I just don't believe in the remote. I think this ever got passed, I think it's just going to be mayhem with all the boards and committees, with a lot of them, and not anybody's going to know what's going on. Thank you.
All right. Anyone else wish to speak on the amendment to HB 308? All right, then we're ready for the question, and I would ask the clerk to please call the roll on Amendment 240H to House Bill 308.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
No.
Clerk Kutab, yes. Rep. Perez. Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Brennan.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
Motion passes 15-5.
All right, so you know what, I think we're done, but I just want to,
We have to vote on the OTPA now.
oh, I'm sorry, okay, yes. All right. All right, so, anyone want to speak any further on the, motion now to, of OTPA? Yes, Representative Wallace.
Let's move the question.
All right, I'll second that. Anyone else wish to speak on that? All right, so now I'd ask the clerk to please call the roll on the main motion of OTPA, House Bill 308 as amended.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
No.
Clerk Kutab, yes. Rep. Perez. Rep. Smith. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Brennan.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
The motion passes 15-5.
Okay, now, I think now we are done except for two things. On 254, Representative Wallace, can I ask you to write the report for the majority report? And Representative Smith, is there someone who will write the minority report?
Yes, Representative Page will write the minority.
Okay, all right. Well, let's,
Yeah, what about 308?
and yeah, exact, report and page. Hang on one second. All right, and on, 308, I guess, Representative Smith has rightly pointed out that I've created a lot of work for myself by writing amendments and stuff like that. But since I wrote the amendment, I'll write the majority report on 308. Will there be a minority report? All right. So I will write the majority, and Representative Andrus will write the minority. All right.
See, we're letting you make these motions. We know you're gonna train yourself out of it pretty soon.
Right. Andrus. All right. So, what I'd like is to say, still, remember, these reports don't have to be long. They don't have to be, very detailed, but I would like to ask to have the reports in again by the close of business tomorrow. So we can get, and I'm imposing the deadline probably more on myself than on other people, but I think it's important that we get this in, so we can get it to the clerk's office. With that, yes, Representative Perez.
Tomorrow, we are not meeting.
The whole house is, I mean, the house, but no, we are not. We are not meeting tomorrow. We are not meeting tomorrow. And you know what? The other thing I would say, as we recess, our Representative Smith has asked if this room can be used for a Democratic caucus, and I said yes. So we need to, when we clear out, we need to clear out so that they have they can take the room for their caucus. So with that, thank you all, and I'll see you tomorrow.
And if I could, I just want to thank our substitute.
Oh, yes, and thanks to our substitutes for being here, for sure.
Oh, okay.
Thank you.
The Democrats, the Democrats on the committee will have a lunch break, and we'll reconvene here at 1 o'clock.